Call the meeting to order. Call the meeting to order. Commissioner Baker.
Present.
Commissioner Bluestone.
Here.
Commissioner Carruthers.
Here.
Commissioner Castillo.
Here.
Commissioner Solomon.
Here.
Commissioner Villanueva.
Here.
And the chair is at long last here. Move to item number 2, which is approval of the agenda. Is there a motion? Second.
So moved.
Second.
Thanks. Any discussion? If not, is there any dissent? Is there an approval of the agenda? All right, hearing no disapproval, we'll move then to item 3. The agenda is approved. Approval of the minutes of the last meeting on December 9th. Is there a motion and a second?
So moved.
All right.
Second.
Any discussion? Not, is there any opposition to approval of the December 9th meeting minutes? Hearing none, the minutes of the December 9th meeting are approved. Item number 4, administrative hearings office presentation. I will leave it to you, Jeremy, to introduce the presenter.
Thank you, Chair. Commissioners, as you know, the commission has a memorandum of understanding that we've had for some years now with the Administrative Hearings Office. The Administrative Hearings Office is a separate state agency. They, as their name suggests, conducts hearings for several state agencies. We do send them work for which we pay them under our memorandum of understanding. And I think it's time for you to meet the Chief Hearing Officer, Brian Van Denzen, and any staff that he would like to introduce, just so that you can get to know this separate state agency that we work closely with. So Brian, thanks for making the time this morning and stepping away from the legislative session and your other duties for a few moments.
Thank you very much, Mr. Ferris and members of the commission, for having us and letting us speak to you. It's only going to be about 5 minutes. I know our time is valuable. As Mr. Ferris said, my name is Brian Van Denzen. I'm the Chief Hearing Officer at the Administrative Hearings Office. I was appointed by then Governor Martinez in 2016 to the first 6-year term of that office. I'm going to describe the office in a bit more detail here in a moment after we do some introductions. And then I was fortunate enough to be reappointed in 2022 to another 6-year term by Governor Lujan Grisham. I've been a hearing officer since 2006, adjudicated thousands of administrative hearings at this point, from run-of-the-mill, high-volume, quick-paced hearings to multiple week-long complex tax protest hearings. And I do have some of my staff with us here today that I do want to introduce and have them say a brief word. Alicia Lucero is on the call. She is our paralegal, and she handles primarily these cases as they come in. She gets the files open, works with the hearing officers, gets everything assigned, and does the billing information on the back end as well. So some of you may see her name on occasion, and I saw her video pop up. That's Ms. Lucero. Alicia, I don't know if you want to say anything, or if I'll leave that up to you. Okay. And then David Buchanan is our hearing officer supervisor in our Albuquerque office, and I am going to turn it over to him in a second. He really is the manager for this hearing program, and I wanted him to be here to introduce himself. So go ahead, Mr. Buchanan.
Good morning, everyone. My name is David Buchanan. I am an administrative law judge, also an attorney with the Administrative Hearings Office. I've been working for the office, the Hearings Office, for the last 16 years as well, since 2006. I came on board right after Brian. And, you know, I've also done thousands of hearings with the Hearings Office, primarily focusing on motor vehicle division related hearings, but also other types of hearings. And we've been excited to work with the Ethics Commission to do some of their cases and handle some of their cases where hearing officers review is necessary. Most of the cases that we've been handling have been reviews of case dismissals and just a second look from a hearing officer to approve those dismissals. And we've enjoyed starting the process working with your agency, your commission. So thank you very much for the opportunity to work with you, and we look forward to a continued strong relationship. Thank you.
And then also another one of our ALJs, Ignacio Gallegos, is on the meeting. Ignacio, go ahead if you want to introduce yourself.
Okay, thank you. My name is Ignacio Gallegos. I am a hearing officer. I've been a hearing officer since 2014. So I'm coming up on 10 years soon. And yes, I've also done thousands of the high volume hearings that we do, mostly motor vehicle. However, I am branching into the tax realm as well as CYFD and the newly created Early Childhood Education and Care Department, which also has a number of hearings. And I believe I've done one ethics review as well. So thank you. I appreciate what you do, and I know it's important work that we all do.
Thank you.
Thank you. And so we have a name, one of those great bureaucratic names, Administrative Hearings Office. What is that? I just gave a presentation to the legislature, and one of the legislators who actually voted to create it said, "What is that?" It's one of those bureaucratic names we never know. So I just want to briefly tell you what we do and then how that ties into obviously your important work. We adjudicate administrative hearings for the executive branch. We started actually as part of the Taxation and Revenue Department. We were the Hearings Bureau of Taxation and Revenue. And then in 2015, I think in an effort by the legislature to promote independence, promote public confidence in the hearing process, and just in general good government, created us separate from Tax and Rev. They administratively attached us to DFA, but really all that means is we submit our budget through DFA. We otherwise operate as an independent agency. And so in 2016, we became the Administrative Hearings Office tasked with conducting and adjudicating fair administrative hearings. We think we share some of the values that you have, those three core things I mentioned: independence of process, promotion of public confidence, and good government. And so I was very happy when Mr. Ferris approached us when you became an agency, a constitutional agency, to work with him, because I think we have a lot of overlap in our mission and our scope and the work that we do. You obviously have a lot more responsibility than we have. We're much more discreet, focused on conducting hearings, and you have a broader mandate than we do. But that's why we so appreciate the work that you've given us. We have all of our hearing officers or administrative law judges at the agency are attorneys, and we have 10 of them. Under our statute, the bulk of our work, it still involves the Taxation and Revenue Department when they're a party to an administrative proceeding. We're the agency tasked with conducting that hearing. So most of our work is still Tax and Rev, and that's why some of the hearing officers mentioned they're doing motor vehicle work and tax protest work. But we also have some other executive branch agencies by statute that we now do work for, including the Human Services Department. And we, again, believing in that mission of good government, we've worked with other executive branch agencies and constitutional agencies. I'm not sure how you refer to yourself, if you're an executive branch constitutional agency or a constitutional agency. We've worked with them on developing MOUs to do some of their administrative hearings. Obviously, we're here today to talk about mostly your hearings, but we have done hearings for the Secretary of State's office. We do medical board hearings, board of nursing hearings. We've done some CYFD hearings, and we just started doing hearings for the new Early Childhood Education and Care Department. And then, of course, we accept referrals from the Ethics Commission, and we've been doing that since FY21. We had 5 cases in FY21. We had 7 in FY22, and we've had 8 so far in FY23. And then one of the new Rulana cases that you all started doing, I believe, this fiscal year. I think Mr. Buchanan described a lot of it is reviewing the recommendations of the General Counsel, but we still value this work. We appreciate the work, and we hope to continue to serve in this capacity, because, as I said, I guess if I want to emphasize anything today, it's that we share those common values of independence of process, good government and public confidence. And so we value being independent decision makers, doing the right thing by the law and the statute over any other influences. And we hope that work is helpful to you as well in fulfilling your mission. And with that, I'm happy to answer any questions about who we are and what we do, or move on. So thank you for your time.
I would like to ask a question about why so many motor vehicle department hearings. What are people appealing?
Of course, Commissioner Carruthers. So I actually have to take a step back. When people are arrested in the state for DWI, there's the obvious criminal aspect of getting arrested for a DWI where you're prosecuted in the criminal court, but also the state motor vehicle department attempts to revoke your driving privileges and make you install an ignition interlock device on your vehicle. Under the Implied Consent Act, you're entitled to have a hearing if you request one before your license is revoked. And that's one of our main hearing types. We did approximately 3,000 of those last year. Probably 6 of our ALJ hearing officers focus primarily on those cases. And then the other hearing type is the tax protest hearings, which are much more complex. And we have 4 of us that really focus on those. And then the other agency hearings I described.
Thank you.
Anyone else?
Yeah, I'm curious. First, I just want to thank you for the explanation and the overview and introduction to your staff. It's helpful to hear about and see. I am curious, though, if you could explain how your fees are set, if that's by statute, if that's negotiated independently, and how that works vis-a-vis our ethics commission.
Thank you, Commissioner Bluestone. Yeah, they're not set by statute. In fact, the statute is silent about whether we can enter into MOUs. When we started doing these other agency hearings, we looked at, and this was before we even did the ethics commission, we looked at what other agencies were contracting with private attorneys to serve as hearing officers. And we thought we sort of use that as a baseline with a reduced rate, because again, we're trying to promote good government, being efficient with state resources. And so we have settled on a baseline rate that we charge all the agencies. It's certainly open to negotiation and discussion. And if Mr. Ferris wants to do that, we can talk more about what that rate is. But I will say early on, when you first became an agency, I did commit to him that we believe in this work, and we're not trying to make money on this work. And if it ever became a problem where there wasn't money necessarily to do the hearings, we still are willing to do the hearings, because that's our mission. We believe in good government, and we want to help you all succeed as well in your work. So we settled on that rate, just looking at the private attorney bar, what they were charging, but we're not looking to generate tons of revenue from this process. We want to be good servants. So we're open to have more discussions about that if that ever becomes an issue.
Yeah, and I wasn't meaning to suggest that it has been an issue. I was just curious about how it was determined. I appreciate your answer a lot, and I respect your commitment to good government and wanting to be of service. And certainly you're doing a great public service to our agency as well as all the others you serve. And we very much so thank you, and we respect your independence and want that certainly to continue.
Thank you. Anyone else? Okay. Thank you very much, Mr. Van Denton. I appreciate your obvious good work and for your time in meeting with us today.
Thank you.
Thank you.
Okay, next matter, item number 5. Casey, I believe this is yours.
Yes, sir. Good morning, commissioners, chair. So back in December, the commission authorized continued investigation and potential civil action concerning District Attorney Bernadine Martin with the Office of the District Attorney for the 11th Judicial District, Division 2. We investigated allegations concerning potential issues with the procurement code, specifically as it related to contracts that the office has with one attorney in particular. And it became clear that the office is not in compliance with the procurement code related to those contracts. But we don't believe that that was an intentional skirting of the procurement code, that they were trying to evade the procurement code, that really what was needed in this case was additional training and ensuring that any procurements moving forward are actually in compliance with the procurement code. We reached out for a potential pre-litigation settlement with DA Martin and her chief procurement officer. And they were very cooperative. They were very willing to discuss with us what the issues were and what they needed to do to correct it. You have in your materials the 2 settlement agreements that were entered. One is with DA Martin herself, and one is with the chief procurement officer, Christina Esquivel. The settlement agreement with DA Martin requires training for everyone in the office for anyone involved in the procurements in the office, that they need to be ensuring that they're correctly trained and certified. And that for these legal services, specifically, that they get a correct request for proposal out, and that those procurements are done according to law. The agreement with the chief procurement officer was essentially that she get more training on the procurement code to ensure that anything moving forward is in compliance with the code. I believe it was 2 days after I sent that initial letter, she actually did that training, and so she is already in compliance with her settlement agreement obligations. And with that, I will stand for any questions.
Thank you. Anybody?
I have a question.
Sure, sir.
Thank you for that explanation. It all seems very reasonable to me, but I'm curious about the status of the contract with the attorney that was entered into on January 1, 21. Does that remain in effect? Has there been a need to renegotiate that, or how does this settlement affect those contract services that were entered into apparently in violation of the procurement code?
Well, so that was a decision that really, because the contract is between the DA's office and this attorney, that those are issues that really she needs to resolve. It's our opinion that those contracts are either void or likely voidable, and we encouraged her to engage in additional contracts as soon as possible. We spoke with her the day after I sent the letter. They had already, the same day I sent the letter, they had an additional sole source determination that they were attempting to enter into with him, and they immediately pulled that as soon as we sent the letter. As soon as we talked to them, they pulled that down, and so that's where those contracts stand. Is that moving forward, those are all going to be done under a request for proposal process.
I'm sorry, you're saying they're moving forward with a request for proposal for those contracts that were already entered into, to either void them or make them voidable to go forward after a proper procurement. Is that what you're getting at?
No, that the prior contracts that is something that while they're void or voidable, the DA's office may still be on the hook for paying out those contracts that under quantum merit, that they may still have to pay those out even if they aren't in compliance with the procurement code. So that's something that she's going to have to sort out on how to deal with those contracts. For any legal services moving forward, however, she is required to do a request for proposal, and we recommended that she do that as soon as possible because of these potential issues, that if the contractor decides not to comply, then she has nothing to go back to. And so what we've required in the settlement agreement is that we be provided copies of any requests for proposals and any contracts entered into based on those.
I appreciate that. And I certainly understand the importance of having full compliance on a going forward basis. But it also seems to me that it might be worthwhile following up to find out what, if anything, that office is doing with those existing contracts, whether there is a way of renegotiating them under the terms of the contract or terminating them in a timely manner, certainly paying, as you were indicating, quantum merit for services that have already been provided. But I would think that it would also be in our office's interest, ensuring compliance with the law, to be in touch with that office to see about providing for corrections as soon as possible, so that contracts that are being entered into by that office and that are continuing to be paid by that office are in as full compliance with the procurement code as possible. I don't know if I'm being clear, but what I'm trying to get at, Casey, is just to be sure that they make full correction as soon as they can, without violating any contract obligations they already have incurred.
Certainly, yeah, I'm certainly happy to double check on that. As I said, when we spoke with her, it was very clear that the office intended to cooperate, that they really were looking for any guidance we could give them on how to make sure that this is correct moving forward. And so they were taking immediate steps to do so. But we can confirm on that.
Okay, I appreciate that. Thank you.
Yeah, I've got a couple of questions. The 11th district, is that up in the northwest part of the state?
Yes. So there are two 11th districts. This is Division 2.
So basically, Farmington, Aztec.
I think this is out in Grants, I believe.
Gallup.
Okay. And my understanding is that these contracts with the DA's office were because of conflicts that they had.
Correct.
And so they needed special prosecutors to move forward with some of these cases.
Yeah, so there were a variety of things that the contracts were for. Part of it was conflict cases. Part of it was this particular attorney had done prosecutorial work with the office before. The office has been really struggling with getting full-time attorneys out there. It's our understanding they only have a couple of prosecutors right now. And so it's really just trying to have enough people to be carrying these cases forward, as well as conflict cases.
And am I correct in understanding that the universe of lawyers in the Gallup area is pretty low?
I think that is probably a good guess. And I will say that this particular attorney, it sounds like, is based out of Albuquerque. And so one of the arguments was that this was an individual who was willing to be out there working on cases. And so we just we're requiring that they expand this to any attorneys who might be interested in doing that work.
Okay, thank you.
Thank you. Anyone else? All right. Thanks very much, Casey. Good work. Jeremy, legislative session update. Anything on your mind?
Quite a few things, Chair. Good morning, Commissioners. So there are many updates with regards to the legislative session. Let me start with the budget request, which is always the appropriate place to start. This I believe is will be the commission's 5th year in HB2. And I think this is our best budget year so far. So the House Appropriation and Finance Committee adopted the executive recommendation, which mirrored our agency's request for just shy of $1.5 million, which would enable the agency to grow to 9 FTE and have 9 FTE on our organizational listing. I've never seen, well, HAFC certainly has never gone with the executive recommendation on the commission's in the commission's request before. So that was very, very welcome. And it's something that I think doesn't happen very often. Normally, the HAFC will go with the LFC's recommendation. And the LFC also gave the commission a very, very good budget recommendation. This year, both recommendations on the executive side and on the LFC side were very favorable, and each would have helped the commission grow in its own way. The executive recommendation helps us bring more FTE on more quickly. And I really think that's how you kind of build and establish a state agency, is with employees as opposed to kind of a contracts budget. We also appeared before Senate Finance, and Senate Finance was very favorable toward the agency's request. They're not taking votes, they're just hearing agency presentations at the moment. So I'm anticipating that we will see the agency's request in the General Appropriations Act of 2023. And Wendy and I will also be watching for the special budget adjustment request authority that we have in the General Appropriations Act to increase the budget by up to $30,000 for revenue that the commission receives from settlements that we receive in litigated cases and any court awarded sanctions or fines or fees. So revenue that we would receive not through the commission's administrative casework, but rather through any litigated actions or court approved fees. So that's the first and the most encouraging update from this session. There's been a little bit of movement on the bills that the commission.
Before you go on, or do you want to wait till the end?
Chair, Commissioner Bluestone, I'm happy to go seriatim with the bills. So yeah, please.
In terms of the budget adjustment request increase authority for $30,000, I'm curious as to how you arrived at that figure as the one to use, and if you gave consideration to a higher amount and what our experience has been in the last couple of years on the monies that have been brought in through those settlements. And I just wanted to get your comments on that.
Sure, thanks, Commissioner Bluestone. So the idea initially, so stepping back one step, the idea initially for budget adjustment request authority is one that we borrowed from the Office of the Attorney General, which I believe is how they bring in the consumer settlements into their agency. And that really helps the Attorney General's office, from my understanding, shore up providing for certain costs in that agency. So that was the origin of the idea. Wendy and I started with $30,000 as a modest amount in comparison to our overall budget, but one that we thought would kind of be sufficiently higher than the settlements that we were likely to receive through litigated actions. As you know, our statutes don't provide for so much in the way that would lead to kind of very large settlements. I think the highest settlement that we could achieve under the Campaign Reporting Act, that statute is capped at a $20,000 fine. So just kind of the $30,000 mark was based on kind of an appreciation for where the statutory fines are across the ethics statutes that the commission has the power to enforce through litigation, and also on our caseload. We have not hit the $30,000 threshold yet. I do not know that we will hit it in FY23, but I do expect that the commission will come close and have a aggregate settlements, perhaps at 25,000, perhaps a little north of that. We settled the litigation against Mr. Vargas and Double Eagle for 13,000. We're currently negotiating a settlement with Working Families Party that's more than 10,000, but we're not at the point yet where it makes sense right now to go and ask for that budget adjustment authority to be increased, to 50,000. We might get there depending on the caseload one day, but we're not there yet.
I appreciate the explanation, and I apologize for interrupting, but I just think it's better as you go through the issues to have discussion. And thank you for that, Dan. It's very clear.
Happy to explain. So with respect to bills that the commission has endorsed, there has been a little bit of positive movement in that regard. So the Campaign Reporting Act bill that the commission recommended in its 2022 annual report, that's sponsored by Senators Worth and Duhigg, received a due pass recommendation out of the Senate Rules Committee and is headed to Senate Judiciary. The other bill that we have an eye on that would involve the Ethics Commission is the House Joint Resolution 1, which creates an independent redistricting commission and would, as drafted, give the State Ethics Commission a significant role in appointing the members of the Independent Redistricting Commission. That bill passed the House Government Elections and Indian Affairs Committee on a 5-2 vote and is headed to House Judiciary. So for the two bills that really that have already passed through committee that significantly affect the commission, those are the two that have already made it through the first step of the committee process. The other significant bills, the Governmental Conduct Act bill that Senator Lopez sponsored on the Senate side, that bill received a 3-committee assignment. The House, I suppose, knew about the language in that bill and is very favorably inclined to what that bill does, and is introducing almost a mirror version, I believe, of the Governmental Conduct Act bill. It's a bill that amends the Governmental Conduct Act in the ways that the commission has already recommended in its annual report. And that bill, from my understanding, will be read in on the House floor today. It will be sponsored by Representatives Jaramillo and Cates, who are 2 freshman representatives on the House side. And my understanding is that the Speaker's office reserved a low House bill number for that Governmental Conduct Act bill. And so I believe it has the support of the Speaker's office on the House side. Our other bills that the commission kind of was involved in developing and endorsing, the Disclosure Act, Senator Tallman's procurement bill, those bills are waiting a committee hearing. Bills that the commission kind of favorably endorsed involving lobbyists. 2 of those are sponsored by Senator Steinborn. They're about more lobbyist disclosure. Those have yet to receive a committee hearing. And a bill or a concept that the commission endorsed about the revolving door between legislators and lobbyists, and the idea of imposing a 2-year cooling off period. That was a concept that Senator Pope independently and separately picked up and introduced a bill in the Senate. That bill has received a due pass in Senate rules and is on its way to Senate Judiciary. So across the ethics bills that the commission has been very involved in, or has just kind of endorsed the concept, there's encouraging movement along those bills at the moment, about 25% of the way through. So Chair, if there are any questions on any of that legislation, I'm happy to provide more before going on to the 3rd chapter of updates.
Mr.
Anything?
Chairman,
Anybody? Yes, sir.
Jeremy, the bill that had 3 referrals to committees, oftentimes that's not a really good sign. Is there any particular problem with that bill?
Chair and Governor Carruthers, I'm not sure why that bill received 3 committee assignments. I've heard rumors. The rumors go to kind of political concerns that don't go to the merits of the bill, I don't believe. But when the 3 committee assignment happened, and when we saw that, we started moving very quickly on the House side to try to see a bill on the House side to give that legislation some momentum. And I'm very encouraged that it's being sponsored by 2 freshmen, that it has a low number, and that it's being read in today.
Thank you.
Anyone else?
I have one question about the Disclosure Act. I'm sorry, Jeff, were you first?
No,
My question about the Disclosure Act is if and hopefully when it gets heard, is there a proposal for us to present an amendment to require that legislators who have close family members, spouses, parents, children that are lobbyists on bills, that there be disclosure about that before votes are taken? Not that they can't vote, but you should have to disclose if a close family member is lobbying a bill. Is there a plan to present an amendment to that concept, which we as a commission have endorsed before?
The chair and Commissioner Bluestone, I have not spoken with Senator Tallman about introducing that amendment. I think I've spoken about the concept with him before, about the idea with him before, and I know he's favorably inclined toward that. And you know, I don't believe he would have any problem with asking for that amendment in Senate rules if it were to receive a hearing. The hang up and the large lift with the Disclosure Act really involves the disclosure of indirect income sources of clients, particularly by the members of the legislature that are professionals, that are lawyers, or that are married and have professional spouses. There is a lot of consternation about the disclosure of clients, and I think that is currently the sticking point, if you will, on that bill.
Thank you.
Thank you. Anyone else? Okay, thanks, Jeremy. Go ahead.
Okay, the third chapter of the updates, commissioners, is I've been informed that there will be a bill introduced that is being developed at the moment on the House side that will seek to amend the State Ethics Commission Act in ways that would add more process, that I think would make it more perhaps onerous, and there'd be more steps in the adjudication of administrative complaints that are filed with the commission. I think that's the opening idea, and once the State Ethics Commission Act is opened up, there's really no telling where it could go. I think the commission should be very suspicious of any amendments to the State Ethics Commission Act that didn't come out of this commission's recommendations. And so it's not a bill yet. I haven't seen it introduced. I don't know when it would be introduced, but it's a legislative effort that, if it were introduced, I think immediately becomes the top priority, and perhaps a major concern. And so that's just an update. We won't have another commission meeting again before the session's over. So I wanted to tell you now and inform you today that I've been told that bill will come this session. I think really, commissioners, it's possibly a reflection that we've been doing our job, and that we've been operating as an independent agency, trying to enforce the law as best as we can. But I also think that this kind of bill was always going to come, just as a consequence of the commission's existence, its role, and the legislature having the power under the Constitution to draft the enabling legislation for the commission and add to or detract from its most of its jurisdiction under the Constitution. So, Mr. Chair, that's the legislative updates.
Anybody?
Mr. Chairman, yes, Jeremy, do you know who inspired this particular drafting of this legislation?
Chair, Governor Crothers, I don't know the individual legislators that are working on it. I do know that there are ideas that are coming both from the House Democrats and the House Republicans, but I don't know right now, and I wasn't told yesterday which particular members are kind of motivating this.
Were you told what problems they're trying to solve with this legislation?
So, Chair and Governor Carruthers, I think one concern that they have is with determinations about probable cause. From their view, a probable cause determination is disruptive reputationally in the same way that a legal conclusion or a set of findings by a hearing officer is reputationally harmful. And so there is a concern that was communicated to me about there needing to be more process leading to the determination of probable cause in the State Ethics Commission. That I think is where the bill will start, but I was also told that there are many other ideas that could affect the commission's operation.
Well, I just advise you, as everybody knows who's worked around Santa Fe, it's easier to kill a bill than it is to pass one. So you might want to keep that in mind, but you have to figure out how to kill it. If it's not desirable, if it's an improvement in the way that the Ethics Commission works, well, I think we would welcome it. But sounds to me like some of them are inspired by this reputational damage and other things that they seem to worry about. And I can understand that too, as well. But anyway, my advice is if it becomes too onerous, you need to figure out a way to kill a bill.
Thank you, Governor.
All right. Thanks very much. Let us now move on to the interactive portion of the program, shall we say. Item number 7, advisory opinion 2023-01. Walker.
Thank you, Chair. Commissioners and Jeremy, we had previously discussed taking these out of order. Do you still want to go in that way, or shall I go? I'm ready to start my presentation now, Jeremy, but.
Please go ahead, Walker.
Chair, this advisory opinion, a draft of which is in the public meeting material starting at page 14, addresses a common question that the commission receives from a high level of generality, and that is a legislator having a financial interest of some form in a company that has its own financial relationship with one or more state agencies. In this particular instance, the requester previously served as an officer of the corporation that holds contracts and grant agreements with various state agencies. The requester has since resigned from that position, but continues to own shares in the corporation and therefore continues to hold a financial interest as defined by the Governmental Conduct Act. So the request was not presented with a sufficient level of specificity about a specific contract, or whether the company was seeking a new contract, or what the type of negotiations were surrounding that contract. So the answer to the question is necessarily a kind of a high level gloss on what legal provisions would apply when the requester encounters something that may affect their financial interest in this corporation. So briefly, the opinion covers the provision in the Constitution, Article 4, Section 28, known as the Emoluments Clause, which governs the legislative creation or authorization of contracts, and prohibits a legislator from having a direct or indirect interest in a contract created during their term of office. That provision, again, the request does not state that any such contracts have been authorized during the requester's legislative term, but the answer sort of covers how that provision might apply to legislation that is passed during the current legislative session and that may authorize one or more state agencies to enter into a contract with the business owned by the legislator. Next, the request covers the Governmental Conduct Act, specifically sections 3 and 9. Section 3, you all have seen a version of this analysis on a number of different occasions. Section 3 prohibits a legislator from using the powers and resources of their office to benefit a private end. And so that provision would operate to prohibit the requester from taking actions that are intended to benefit his or her interest in the corporation. Now, the opinion does note that there may be issues surrounding whether or not the commission can actually adjudicate a complaint. For example, if the alleged violation of a complaint alleging a violation of 3A based on a vote, would likely be outside the commission's jurisdiction under the speech or debate clause of the New Mexico Constitution. Section 3C covers the duty of disclosure of real and potential conflicts of interest. The legislator is under a duty to make full disclosure of real or potential conflicts of interest and a duty to avoid undue influence and abuse of office in public service. The opinion really only covers the disclosure obligation because the request doesn't suggest a potential abuse of office that requires analysis. The opinion sets forth, I think, what is new, but I think important point, which is that the Financial Disclosure Act, I think, sort of occupies the field when it comes to financial disclosures. And while Section 3C can be read as encouraging legislators to make additional disclosures of their real or potential conflicts of interest, for example, before they vote on a bill in committee or on the floor, generally the view articulated in this opinion is that a full disclosure of the requester's interest in this corporation in their annual financial disclosure statement is likely going to satisfy their disclosure obligation under Section 3C. The opinion then covers Section 9 of the Governmental Conduct Act. There are two parts of Section 9. Subsection A requires a state agency to undertake certain, it imposes certain prerequisites on a state agency's ability to enter into a contract for services, construction, or items of tangible personal property with a legislator's family or with a business in which a legislator has a substantial interest. In that instance, the legislator must disclose their substantial interest, and the contract must be awarded in accordance with the provisions of the procurement code, and may not be a sole source or small purchase contract. So that obligation, technically doesn't really attach to the requester. It's an obligation that falls on the state agency that's awarding the contract, but the provision is covered under the advisory opinion and is going to apply to any contract between the requester's business and a state agency. Again, there's no suggestion in the request that there's been a violation of this provision. Next is subsection B, which governs appearances, representation, or assistance to another person in matters before state agencies. This advisory opinion contains an analysis of that provision, notes that because a corporation is considered a person under the Uniform Statutes and Rural Construction Act, the requester appearing for, representing, or assisting that corporation in a matter before a state agency is subject to subsection B, and the appearance would only be permitted if it's without compensation or for the benefit of a constituent. Excuse me. And because the corporation is because the requester is receiving compensation, whether, directly, probably unlikely directly for whatever representation or assistance might be rendered, but just generally as a result of the ownership interest. The opinion concludes that the legislator is likely barred from appearing for, representing, or assisting the corporation in a matter before a state agency. The analysis also covers the exceptions to that provision. It covers the, without pay, for the benefit of a constituent, and the professional persons exception, which doesn't apply in this request, because according to the request, the requester is not a attorney or other professional person engaged in the conduct of their profession. So that's kind of a broad overview of the opinion, and I happy to answer any questions, and I would be seeking a motion to approve and issue this formal advisory opinion 2023.
Thank you. Is there a motion, a second?
So moved.
Second.
Thanks. Discussion, questions?
Yep.
Mr. Baker? Jeff? Mr. Baker, anything?
I just had a question. I'm looking at page SEC 23, which is the conclusion. And there's a sentence which reads, it's about halfway through the conclusion. The disclosure of the requested employment and ownership of the corporation on the requester's annual financial disclosure statement is sufficient to fulfill the disclosure's obligation for potential conflicts of interest under the Governmental Conduct Act. And so my question is, do we know if in practice those financial disclosure statements are indeed sufficient to alert folks to conflicts and to prevent them?
Chair and Commissioner Baker, I think that with broadly speaking, I would say no. And that's because, there are contracts for an amount of less than $5,000. There are a number of different financial interests that aren't going to show up on the annual financial disclosure statement. And so, generally speaking, I think you can point to problems in the way the financial disclosure statements are structured and what they require by way of disclosure, and that I think informs is I think the reason behind the Commission's efforts, both in drafting and trying to get a hearing and passage of the Disclosure Act to make sure that there is more comprehensive disclosure of income sources and financial interests. In this case, the requester formerly was an officer. I don't know whether that included employment by way of a salary. I don't know whether this corporation has a board of directors on which the requester sits. Those are the two ways that disclosure of business ownership or having a high level officer position in a business would be disclosed on the financial disclosure statement that is annually filed.
Thank you.
Mr. Bluestone?
Thank you, Mr. Chairman. I think the opinion is very well done in almost every aspect, and I think it's going to provide helpful guidance. I commend you, Walker, on the work in it and what it reflects. But I do have one question as I look at it now about one sentence, and it concerns this issue that we're going to be discussing later this morning regarding 1016B on legislators providing assistance to people. And it's on the public materials page SEC 22, which is page 9 of this opinion. And you go through, I think, entirely appropriately about the provisions of 1016.9 on the different exceptions and what doesn't apply here. But in the final paragraph, I don't think you need the the second sentence, and I think it raises an issue that we're going to be discussing in more detail later this morning, this afternoon. The last paragraph begins with the sentence that says, because an exception does not apply, Section 10 prohibits the requester from appearing for, representing, or assisting the corporation before a state agency. I think that's the main point, and that you can end the discussion right then and there. I think the second sentence in that paragraph is not needed and addresses an issue that we're going to be discussing in more detail later. And I would rather delete it from this opinion because I don't think it's necessary to it. And it raises the issue about if a legislator is assisting a constituent or somebody and they're not getting paid, are they still prohibited from staying with their legislators and using their legislative stationery? And I think that's a separate issue that we need to have separate discussion about. So I would recommend, if you're okay with that, Walker, particularly in the context of this particular opinion, that we just strike that last sentence of that paragraph on page 9 of the proposed opinion. And I'd like to make a motion to that effect. Hopefully it's with Walker's agreement, but that's the concern I wanted to raise now in looking at the opinion.
Chair and Commissioner Bluestone, you know, I think I tend to agree with you that the inclusion of that sentence is, you know, I guess if we were acting in pure judicial capacity, you'd call it dicta. So, you know, I don't have any opposition to removing it from this advisory opinion. However, you know, as you mentioned, this is part of an ongoing discussion, and you know, this statement is I think a gloss on a consistent staff interpretation of subsection 9B. And so, you know, whether
you're okay with striking that sentence?
Yeah.
Okay. There was a motion in the second. Are the mover and the seconder okay with amending the motion to include striking that particular offensive sentence? Whoever moved and seconded the approval of the.
I don't know if there was a motion, but
Yeah,
Okay.
there was a motion in the second, and then we go to discussion. So it was moved and seconded. I am going to assume hearing silence, because we all know that silence tokens consent. That the statement will be, the sentence on page 9 of the opinion will be stricken. And so that's the motion on the table. Is there any other discussion? All right, there's a motion in the second that has been amended. Commissioner Baker, to approve, to issue the opinion.
Yeah, I understand. I'm just going to vote present.
Okay. Commissioner Bluestone?
So I'm clear, this is a motion to accept the opinion, having
As
stricken-
amended, with the amendment that you have suggested.
Yes,
Okay. Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. Motion passes 6-0 with Commissioner Baker voting present. All right, the next matter.
Okay, commissioners, this is a second advisory opinion of the year. It's quite similar to the advisory opinion that Walker just detailed and that you just approved. It's more limited in its analysis because the question is somewhat more limited. The question is on the following facts: a legislator's children owns and operates a company that has contracts with state agencies. Those contracts are awarded pursuant to a competitive process under the procurement code. The company that the children own rents storage space from the legislator. And the legislator has asked what conduct and disclosure requirements apply to him because of this relationship with his children's business, that he rents storage space to the children's company that have contracts with state agencies. And the advisory opinion just it's very similar to other advisory opinions that the commission has issued on similar questions before. It provides guidance on Section 9A of the Governmental Conduct Act, which regards state agencies entering contracts with legislators' family members. Under the facts presented, the section really doesn't prohibit the contract because the legislators, or impose really any constraints on the contract because the legislator doesn't appear to have a substantial interest, which is an ownership interest greater than 20% under the Governmental Conduct Act. And in any case, the facts stipulate that the state agency contracts were awarded pursuant to a competitive process. Similarly, the advisory opinion details the law of Section 9B with respect to representation if the member ever were inclined to represent his children's business before a state agency. I don't know, Commissioner Bluestone, if this opinion has the same concern as the prior opinion, but I'd ask you to take a look if you don't mind. And that would be on SEC 26 and 27. The opinion goes on and provides an analysis of Section 3 of the Governmental Conduct Act, which you have seen before and are now well familiar with respect to the requirements of subsections A and C of the Governmental Conduct Act. And finally, the way in which this advisory opinion is somewhat different than others is it provides maybe more of an analysis as to the emoluments clause. The legislator's interest in the children's company, although indirect, is probably an interest that triggers the application of Article 4, Section 28 of the Constitution, the emoluments clause. And so long as the legislator has an indirect interest in the children's company, that would mean that the legislator couldn't have an interest, direct or indirect, if the contract were authorized by legislation that was enacted during the legislator's term. The facts don't provide any indication whether or not the legislation that authorizes these contracts between a state agency and the legislator's children's company, whether or not that legislation happened recently or decades ago. But the advisory opinion does point out that if there is new legislation that authorizes the state agency to enter into new contracts that the children's company might have an interest in, that the emoluments clause would bar the legislator's indirect interest, and to the effect that the children might have to find another place to store their company's material. And the last part of the emoluments clause analysis that is important, and it's well-established law in New Mexico, that the General Appropriations Act, other appropriation acts that appropriate funds to state agencies, that's not law that authorizes a contract under the meaning of the emoluments clause. And so with that, Chair, I would ask that the commission issue this advisory opinion.
All right, is there a motion and a second to so issue?
So moved.
Thanks. It's moved and seconded. Any discussion?
Yes, I do have a comment.
Go ahead.
Yes, thanks, Jeremy. Again, I think this is an excellent opinion, very similar to the one we just reviewed, and provides good guidance and overview of the issues. But I still have that same concern, as you indicated, might appear It's just with one sentence that I don't think is needed in the opinion in the discussion of 1069 that we're going to talk about more later. So that's a sentence that's at the very bottom of page 3 of the opinion, page SEC 26 of the public materials. And it just, it starts, if an exception applies and operates to permit a legislator to appear for, represent, or assist another person in a matter before an agency, the legislator is nonetheless prohibited from making references to the legislative capacity except as matters of scheduling, etc. It's the same sentence that we just struck in the prior opinion, and I would move that we strike that sentence also as not being necessary and as being something we're going to have further discussion about later. But I like the whole opinion, and I'm happy to vote for it with that sentence being stricken. And I hope
Jeremy?
Jeremy agrees with that.
Jeremy?
Yes, sir. I would consider that a friendly amendment, as they say in the legislature.
Okay. All right. Any other discussion? All right, it was moved and seconded, the mover and seconder, whoever all you were. Is there any objection to modifying the motion in the second to include for removal of that sentence?
No objection.
All right, hearing none, then the motion as amended is before us to issue the opinion as amended. Commissioner Baker,
Present.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes, 6-2-0 with one vote for present. And we are glad you are present, by the way, Jeff. Let that not go unsaid. All right, the next matter that also is yours, Jeremy, and it's one from last year.
Chair, would the commission mind if we took a 4-minute break?
Nope.
A restroom break before we move to this item?
Nope, the chair's prerogative. We're so taking. Let's make it 5 minutes. This is agenda item number 9.
Okay, thank you, Chair and Commissioners. This is an item that concerns the interpretation of Section 9B of the Governmental Conduct Act, and an issue that has arisen in that interpretation. What I'd like to do in presenting this is for us to go through the statute together. I'd like to review the statute first, then I'd like to review why this is an issue now, why it's before us today. And then third, I'd like to offer you a recommendation as to the action the commission should take on this agenda item. So that's the plan. The Section 9B, if you'll follow along with me on SEC 32, this is a memorandum that I wrote to you on January 23rd in anticipation of today. And on SEC 32, we can kind of look at and explore this statutory language, this statute. This is a statute about when legislators can represent persons in matters before state agencies. This statute is, I think, no matter how you're coming at this statute, there are 3 things that anyone could agree that the statute does. The first thing is that the statute, it has a default rule. It's prohibiting legislators from appearing for and representing, assisting persons in matters before state agencies. And in person here, that means an individual, it means a business, it means a nonprofit organization. It's a capacious term under the Uniform Statutory and Construction Act. It does not mean the government, but it means individuals and businesses and nonprofits. So the default rule is a legislator can't do that. It can't represent a business in a matter before a state agency. And then it provides some exceptions to the default rule. The first is unless they're making that appearance without compensation, that they're not paid The second is unless it's for the benefit of a constituent. In that instance, the legislator could appear for or represent another person. And then there's another kind of allowance that legislators who are attorneys and professionals in the conduct of their profession, well, they can also represent persons before state agencies. And they can do so if they're paid, and they can do so even if the person isn't a constituent. So there's the default rule, and there's some exceptions to the default rule when legislators may represent persons before state agencies. And then third, there is the statute is applying some prohibitions on what a legislator cannot do when they are engaged in a representation. And this comes together as a package. The legislator must refrain from references to their legislative capacity unless they're talking about scheduling. They can't use their legislative stationery, and they can't make threats or implications relating to legislative action directed toward the state agency. And the hard question about 9B is that package of prohibitions to which permissible representations does that package of prohibitions apply? And the question of kind of statutory interpretation here is whether or not that package of prohibitions applies only when the lawyer or only when the legislator is an attorney or other professional person engaged in the conduct of their profession. When they're representing a person in that circumstance, do the prohibitions apply there only? Or do the prohibitions apply in any circumstance in which under 9B, the legislator may permissibly represent a person before a state agency? And one way of kind of just, I think, putting the question to a point is, yeah, that the phrase that I've bolded here on 32, in those instances, what are the instances that that term refers to? Is it just representations by a legislator or attorney engaged in the conduct of their profession, or is it instances where a legislator is allowed to do a representation of a person before a state agency in every way that that's permitted? So that's I think an overview of the question. Since the commission's attorney staff have confronted this statute, and we first confronted it in the course of administrative cases appearing before the commission. The attorney staff here have taken the view that that package of prohibitions that applies under the statute whenever a legislator is conducting a permissible representation. And we first, as I indicated in the memo, we first kind of explored this statute in the administrative case 2020-31 Whitlock versus Dow. And then since then, we've also had occasion to explore this statute in an informal advisory opinion that Walker issued in response to a question that was raised by a legislator, I believe, through an attorney at the Legislative Counsel Service. So in kind of two instances, applications of the commission's work, have we kind of confronted this question head on. I think it came up most recently because, as you know, I'm required to give a biannual ethics training, or the members are required to receive a biannual ethics training every 2 years, either from the commission or from the National Conference of State Legislatures, or some combination thereof. In this past year, in December in the Roundhouse, Mark Weiner from the National Conference of State Legislators and I gave an ethics presentation. And my presentation was addressed to the different ethics laws that apply to the members. And when I was presenting on Section 9B, I presented the attorney staff's view of this statute, that the package of prohibitions that's going to apply if they're representing a person in a matter before a state agency. They can't make threats, they can't refer to their legislative capacity, and they can't use their stationery. Immediately after that presentation, several members came up to me after and wanted to discuss this issue. And then shortly after that, we began to receive, requests for informal advisory opinions on the question, which we prepared and issued. Walker issued the informal advisory opinion that's attached. The lawyer who works for the council service who asked for the opinion asked for a reconsideration, and then shortly thereafter, the chair, Judge Lang, received a request from Senators Worth and Baca that the commission consider this issue and rescind the informal advisory opinion. And so that's how the issue kind of becomes presented before the commission today. Chair and commissioners, what I propose and what I recommend that the commission do in response to these requests is to respond to the senators recommending language that improves this statute, and that removes the ambiguity regarding the application of that phrase in those instances and where that package of prohibition applies. The recommended language that's before you is on pages 38 and 39 of the commission's materials. And before I go through that, I want to emphasize that the informal advisory opinions that the attorney staff issues, those are not binding on you. They are not binding on the hearing officer in an administrative case. As you know, the commission issued that rule under the New Mexico Administrative Code to allow the commission to provide guidance to requesters in a more timely way than we can otherwise do through formal opinions. And as you know, we issue these informal opinions to many folks in local governments around the state often, and we turn them around quickly. And because of how they're prepared and because of the volume of requests for informal opinions that we received, they're not binding, they're not published on one source. And so I don't think that a rescission of an informal letter, advisory letter, is really the right path forward here. I think the right path forward rather is to propose a statutory amendment that gets this statute 9B to a better place, a more clear place. And so that language, Chair and Commissioners, is before you at SEC 38 and 39. And I have discussed this language with some of the commissioners, and I think that there are some adjustments that we can make to this language in the commission's recommendation that would improve it from where it is right now. But before that discussion, Chair, I just want to kind of point out what the language as written does. So the recommendation would, again, to start with the same default rule. Members shall not appear for, represent, or assist other persons in matters before state agencies, and then provide clearly when they can. And that would be if they're not paid, or rather, and it's for the benefit of a constituent, and they're not interested. And so that's the circumstance in which a non-professional, non-attorney legislator under the recommended language could represent another person in a matter before a state agency. The second part of the recommended language addresses exclusively members who are representing clients in matters before state agencies as professionals engaged in the conduct of their profession, and makes clear that in those instances, the lawyer legislator shouldn't be using their stationery. They can use their firm letterhead in that aspect. And then last, the recommended language makes clear that no matter how the legislator is permitted to represent a person before a state agency, they can't make threats. What this language does is it in essence would allow non-professional legislators, non-lawyer legislators, when they are representing or assisting persons before state agencies, so long as they're not paid and they're not interested, to use their legislative stationery, and perhaps even to sign their emails indicating that they are a member of the New Mexico legislature. And so, Chair, that's I do want to have a discussion about how this language could be made better than as it is. And Chair and Commissioners, I also want to inform you that I'm under the impression that in the bill that will be read in this morning to amend the GCA, that some version of this language will likely be in that bill also. And so there is a kind of starting point for working on a legislative kind of solution to an issue of statutory interpretation. This issue and the arguments that surround this issue can go much deeper than my kind of initial presentation, and there's a lot to consider and think about here. But I think that's a sufficient and fair introduction, and so what I would recommend you do is recommend the amendment, an amendment to the statute that's based on the language in SEC 38 and 39. So thank you.
Thank you. All right, let's begin. Is there a motion and a second to adopt that proposed legislative language change?
So moved.
Second.
Okay, motion and second. Let's go with some discussion, I assume. Commissioner Baker, anything?
Yeah, I just want to make sure that I understand. Is this proposal, would this proposal allow a lawyer legislator to appear before a state agency and be paid for that representation, so long as he or she does not use their legislative stationery, and so long as they do not make any threats with respect to their position in the legislature?
Chair and Commissioner Baker, the answer is yes. This language, if it were law, would allow a lawyer legislator to represent a client before a state agency, to be paid for that representation, and when doing so, they could not use their stationery, make reference to their capacity, or make threats or implications.
Well, I just want to suggest that I don't think this goes far enough, and I don't know what kind of appetite there might be at the legislature, but I do not think a legislator should be paid to represent a constituent or some other person or entity in front of a state agency. So, for example, if Jeff Baker is elected Speaker of the House,
God forbid.
God forbid, indeed, and I'm licensed as a lawyer, and ExxonMobil wants to hire me in front of state tax and rev. The fact that I'm not saying, oh, by the way, I'm Speaker of the House, and oh, by the way, here's my legislative stationery, everybody at state tax and rev is going to know who I am. And I don't like it. And so I think that your proposed language, while it is an improvement, I don't think it goes far enough. I just think that legislators ought not to be paid money to represent folks in front of state agencies.
Chair and Commissioner Baker, I think that you make an excellent point. The argument that you're making, I know, is one that has been discussed now going on 3 decades ago when the 93 task force discussed amendments to the Governmental Conduct Act. And that very argument that you just made, I think, was in the mix in the development of this statutory language. The statute came out that task force report makes clear as a kind of compromise that there was a concern about that if lawyers weren't allowed to have business before state agencies, that it might deter a certain section of the population from being willing to serve. That's part of the 93 task force report. You might not buy the argument. The argument you make, I think, is a sound and principled one. The language you have before you kind of builds on and continues the compromise, I think, that was reached in 93 and just tries to make it a little more clear to address the issue that we've confronted now.
Thank you.
Thank you. Stuart?
Thank you. And thanks for the explanation, Jeremy. Let me begin by saying that I think that the work that our staff does with informal advisory opinions is extremely helpful. I think they do a great job of providing prompt and very helpful responses on a range of ethics issues. And I think that this process has worked really well, particularly compared to what unfortunately has been the case before, where people would make requests for opinions from like the Attorney General's office, and it would take months, if not years, until a response would be issued. So I really like the way our informal advisory process is working. I don't think, in terms of the request that's been made by the Senators Worth and Baca, for us to withdraw the informal opinion. I don't really think we have an option and a procedure for doing that. I mean, we can issue formal opinions, but I don't think we really have a way of withdrawing an informal opinion. And I think that the issue is one that I read the statute, I think, more the way the staff of the Legislative Counsel Service and Senators Worth and Baca have read it, which is that legislators are allowed to do things without compensation and to represent constituents and to refer to themselves as legislators and help their constituents as legislators and help interest groups, whether it's on one side of an issue or another side of the issue, because they care about the issue, and to say that they're legislators. And I think the most reasonable interpretation of the existing language is to interpret it so that what it means is that when they are getting paid to represent someone, that's when they're not allowed to make reference to their legislative position and use their legislative stationery and things like that. So I frankly think that I have a different interpretation than the one that the staff have provided that I think is more consistent with the existing language in the statute. But I don't think that the staff's position is what I would call a wholly unreasonable one, and I think, as Jeremy's explained, it does take a more aggressive and expansive reading is not to tinker with an advisory opinion or try to have us draft a different formal advisory opinion. I think that, as Jeremy has suggested, that the easiest and the best solution is to make an amendment to the statute so that it's crystal clear on a going forward basis. But I don't think this language that Jeremy has shown us here does that. And so I think it needs to have some changes. And I'm looking at SEC 38 and 39. And I think that a legislator can always do anything to benefit a constituent. That's their job. And so the way I read it, and I reviewed this with Jeremy yesterday, and I think he agrees, but he can speak for himself. If we take out under this subsection B, take out the that it would read as provided in subsection C of this section, a legislator appear for, represent, or assist another person in a matter before a state agency, unless that appearance, representation, or assistance is provided without compensation and not a matter that affects the legislator's financial interest or position. Just strike the number 2 about for the benefit of a constituent, because I think they can always do that with or without compensation to serve their constituents. And then similarly, in subsection C, you're really only talking about when the legislator is getting paid. They appear for when they're engaged in the conduct of their profession, but if they do so, they shall not make references to their legislative capacity or use legislative stationery, legislative or other indicia when appearing for, representing, or assisting a client in a matter before a state agency. So I would take out the words constituent or, because I think a legislator can always make reference and do work for their constituents. And that's their job, is to represent their constituents, whether it's before agencies or others to help get those interests pursued. So I think I'm in agreement that the best thing to do is to just propose a statutory fix, but I don't think the language that we have before us does it. I am okay if we strike out those words that I just talked about, that subparagraph 2 under B, and the words a constituent in C, and I'm okay with us going forward on that basis as getting the quickest, the best and the cleanest fix. But I just want to say that with all due respect, if I were just interpreting the statute as it currently is, I would have a different view than the one that the staff's put forward on how it applies the interpretation of those words in those instances. I think that just applies to when the legislator's getting paid. So I don't know if I'm being clear, but that's my sense. And Jeremy, did I accurately describe what we talked about yesterday too, that you agreed to?
So Chair and Commissioner Bluestone, yes, I think that the those changes to the statute are fine from my vantage, and kind of go toward providing more clarity in this statute. I do want to point out that part of the staff's interpretation, it does revolve around non-lawyer legislators being paid. And so to go back to SEC 32, where the statute is there, you'll see that I bolded both the phrase in those instances, but in the first sentence, the word or. And that's been a little word that's always troubled the attorney staff. It's different, the House rule on representation, the rule of the House of Representatives, is word for word the same as this statute in the Governmental Conduct Act, but instead of the word or, it has the word and. We have seen in the course of administrative cases before us, non-professional legislators who were representing persons before state agencies, arguably for the benefit of a constituent and being paid to do so. And this little change from and to or seems to allow legislators to represent and assist other persons, other businesses, nonprofits, individuals in matters before state agencies, even if they're not lawyers or professionals, and be paid to do so, so long as they're doing the representation for a benefit of a constituent. And so if they are paid to do so, if they are allowed to represent constituents or organizations for the benefit of constituents and be paid to do so, that the same prohibitions that apply to legislators when representing clients before state agencies ought to apply to them as well. And so the question of pay, to Commissioner Bluestone's point, has certainly motivated the staff's interpretation of this statute since we first encountered it a few years ago. But Chair and Commissioner Bluestone, the language changes that Commissioner Bluestone recommends, I think, go toward improving a recommendation.
Thank you. Anything else, Stuart?
Nope. If we're in agreement with that, I
Thank you.
think the legislative fix is the best way to go forward.
Thank you. Governor?
Well, first of all, I think we're going to have to go back and listen to Stuart's recommendations. I was fixated on the document that I have before me that continues to reference attorneys. I have no clue in the world why attorneys are special in that they can do this and or other licensed professionals. For example, I'm an economist, and there are agencies and issues that economists can be very helpful. And for a good friend of mine is one of the go-to economists for energy issues and taxation and anything energy. And yet, if he were a legislator, would he be able to represent a client before an agency, but he's not a licensed professional economist, as a rule, are not licensed. There are agronomists who would testify before the the New Mexico Department of Agriculture, but they're PhDs, but they're not licensed. So why do we cater to attorneys in this particular case? Is this because everybody's fearful that they're so powerful that you can't take this away? Why do you have to be a licensed professional to be able to represent, even if you're a legislature before an agency? So let's go back and Stuart, remind me what you just said. I wasn't focusing on the particular part that you were focusing on. What does your cleanup do to make this not just a let's take care of the attorney's deal?
Thank you, Governor. I think that the language that Jeremy is putting before us is not limited just to attorneys. It's to an attorney or other professional.
Other licensed professionals.
So the language he has is for other professional, not licensed. On page 39, SEC 39.
Well, just a second, I must be on the wrong page. On 39, I read to you. It says, acting as an attorneys or other licensed professionals is what mine. Do I have an old copy?
I think so, Governor. Jeremy, do you have that on the current
I'm looking
version?
on page, I'm looking on SEC 39.
Right.
This prohibition does not apply to legislators acting as attorneys or other licensed professionals. There are a lot of people who are not licensed who have something to contribute. Let me go back to my example. I'm an economist, but I'm not a licensed economist, but I'm a professional economist, but I'm not licensed. We don't license economists. So There are agronomists who might want to speak to the New Mexico Department of Agriculture, who are PhD agronomists who have something to say on behalf of their constituency, but they're not licensed. So why this baloney about being licensed professional? Why are we catering all of a sudden to the attorneys and licensed professionals? There are a lot of other people out there with some attitudes. There are many geologists who are not necessarily licensed, who have a lot to say about oil and gas industry. So what the heck are we doing here? Just sucking up to attorneys?
No, I agree with you, Governor. I just think, Jeremy, we're not reading the same thing.
I agree. I'm reading the same thing, sure. I agree with you also, Governor, on your position, but I'm looking at what was submitted on SEC 39, particularly paragraph C.
I'm under B. I'm on B.
Yeah, I think what happened is a new version.
Yeah.
Was sent out within the last day or two.
Right.
And so the
Jeremy,
new language
that?
does not have the word licensed.
Right, because I don't see it on mine either. Jeremy,
Okay.
can you take a look at that for the gov, please?
Sure. Governor, it is the case that I sent two links to the commissioners. One perhaps the week before last, and then more recently a link that did make a change here. That's the one that Stewart or Commissioner Bluestone and the chair are looking at. So it's possible that that we're looking at different links. So let me.
Okay, you're on. Are you on SEC 39? That's the agenda I'm working off of. Am I on the wrong agenda? Is this the State Ethics Commission meeting?
It is.
Okay, good.
We are on SEC 39. The language that we're looking at does not have the word licensed professional. But let me go to the substance of your question. Even if the language didn't have licensed professional and the language just said professional, I think that it does matter that in certain professions that the state provide a license, because for professional licenses, that often means that there are rules of professional conduct that are associated with those licenses. And that's a fact that's true of attorneys. It's true of other professions. I don't know if it's true of economists. I don't know too much about economists, but
Yeah, we don't have a lot of ethics to bother about.
So I think that to the substance of your question about a focus on licensed professionals, I think it's always fair to suspect that these statutes, when they're drafted up by attorneys, might have an angle of protectionism in there. I think that's always a fair suspicion. But when thinking about what is the application of the term professional, I think it's fair to think about the application of that term to professionals that are licensed by the state because of the rules of professional conduct that are attached there too.
Okay, well, I'm going to back on out of this and go back to find the right agenda. I opened, I thought, the one that was sent when it says State Ethics Commission meeting materials for February 3rd, 2023. So why is there a later one than that? It says this one is January 19th, apparently was sent out, but I was operating on the last one. So where did I get the one that you're talking about? I'm under public materials.
I believe it was sent yesterday.
Chair, The agenda you're looking for, the materials you're looking for was sent on the 31st of January. And it also says materials for February 3rd meeting.
Okay, well, you need to, the one I'm operating off of was probably sent earlier, so I need to have, although I was actually tracking pretty well. You want to send me the one that was last night, midnight, or whenever you sent it? And I'll start over again.
Jeremy, can somebody send that to him? Jeremy, are you there?
He's trying to, I think,
Okay,
Sorry, I was on mute. Yeah, I'm sending that email right now.
okay, thank you.
because I'd like to see the language. I'm now getting a little cantankerous about licensed professionals and attorneys getting special privilege, but whatever.
All right, Governor, you have the links.
They're not here yet. But why don't you go ahead with the discussion, get others, and it'll come ultimately. I'm pretty far south here, and so it takes a while to get here.
The road runners haven't got their chain together.
Yeah.
Commissioner Solomon, do you have anything you'd like to entertain in this discussion?
Turn the mic on first. Thank you. You know, the thoughts I had were very similar to Governor Carruthers in terms of my experience at the legislature and people that I've appeared with, or people that have appeared on behalf of different organizations, tribal people, and others. And much of the time we have folks I know in the past that have had a combination of credentials in terms of being like registered professional engineers. I don't know that they fall within this category. And then we've also, in dealing with state agencies and other relevant agencies, have had hydrologists. And you know, right now with all the water rights, water claims, and all of that is happening, we've had people that make appearances. In some cases, that's part of the background that they bring into the legislature. Is those in many cases, I think there's a broad sort of concept or approach to what a professional is outside the practice of law and medicine. So there's a range of folks that are brought in, and as Governor Carruthers mentioned, the economists too, when we get into economic development matters and proposed legislation, actions by agencies, those kind of things that involve people that are within the range of professionalism. And I don't know, I didn't have enough time to look at if there's a definition anywhere that has to do with, well, what is a professional in terms of New Mexico law? So that was a sort of a similar concern that I had, and those are the kind of folks that came to mind based on the discussion that one, the proposed language, and then Stewart's discussion, and then more so with Governor Carruthers' input on this subject matter. So the question that I had too was the timing on this. If we're looking at the proposed language, when do we offer it? When do we put it forward? Are we talking about preparing for a response to this sort of clique of folks that are developing language that we're anticipating is going to be introduced? Or are we anticipating putting it forward at some other time? So that's more of a strategic question there. Thank you.
Thank you. Jeremy, you want to answer that last question?
Sure. Chair and Commissioner Solomon, the idea would be to provide a response to the senators that requested action by the commission kind of expeditiously as soon as the commission kind of comes to an action. So it would be something that would be for, you know, what's going on right now in the session, and to respond promptly to the senators that made the request to the commission.
Okay, I've read this over again, and the term is professional, not licensed professionals in this. Is that correct? Am I on the right one now?
Yes, sir.
Okay, I see that. And so you're saying in this particular one, it's showing without compensation for the benefit of the constituent. That doesn't affect the legislature's financial interests, and we go back to other professional making representative engage in the conduct. Okay. So you're restricting their use of their mail. Okay, I'm sorry, I was on the last month's agenda. Sorry about that.
Thank you, Governor. Celia, I'm sorry, I jumped over. I wasn't looking at my cheat sheet, and I forget the alphabet periodically. So do you have anything you want to add to the discussion?
Yes, I do, as a matter of fact, and there's no problem with the order. I agree that clearing up a statute that is as unclear as this one is a good thing. It's a good thing for New Mexicans, and it's a good thing for the legislators, so they know where they stand. And listening to all of you, you have great ideas, and I did talk to Jeremy a little bit about the language in the proposed change, because I had problems with it, similar to Stuart's problems. But now, listening to everybody, I have even more problems. I think what we're trying to do here is say that legislators who assist persons in front of a state agency and do not get paid, okay, can go ahead and use their stationery and their email and so forth. Because even when they're not doing it for a constituent, they are essentially doing it for the benefit of New Mexicans, and they're not getting paid. And so they're doing their legislative acts. However, when they're not in that particular position, because they are getting paid, they are now either an independent contractor or something like that, they should not be able to use their legislative badges, the email, the stationery, and so forth. And I don't think it makes any difference whether they're a professional or not. If they're getting paid, they should not be able to use the email, the stationery, etc. So I think that's really where I think this ought to set out, and that would be clear to legislators. When they're getting paid, they can't use it. When they're not getting paid, when they're getting paid, they cannot. When they're not getting paid, they can. And that would also answer Governor Crother's question about who, you know, how professional do you have to be? Then the other question I have is, as far as the bill itself is concerned, if it's put with another bill and that bill doesn't pass, then this doesn't pass. Should it be in a separate bill itself? Because the whole idea is to clean it up and clarify this for everybody.
Thank you, Jeremy.
Thanks, Chair. Commissioner Foy Castillo. To your first. Well, let me go in reverse order. All the commission can do is can make a recommendation, and perhaps you know, a member is inclined to run a bill separately, just, you know, that addresses this one provision of the Governmental Conduct Act. And you know what, I haven't seen the language that, you know, I anticipate is maybe even being read in right now on the Governmental Conduct Act that tracks to some extent, I think, this language. But yeah, to your point, Commissioner Foy Castillo, you know, if we can get the recommendation right that has the consent of the commission, then, you know, perhaps a number of legislators on different sides of the aisle might pick it up on different chambers and try to reform the Governmental Conduct Act. To your point on further amendments to the recommendation, I actually think you make a good point here that in a way, I take it what you're suggesting is that we don't recommend this stuff about professionals, and you just get right to the point about whether or not you're being paid or not. I think the language, in a roundabout way, is trying to get at that same concern, and this goes to Commissioner Bluestone's point about removing the term constituent or in C, and just goes right to client. And I think it's reasonable to read that use of that term client exclusively to mean that that's an instance where the legislator is being paid. So I think it's not as elegant as what you just suggested, but it is attaching the prohibitions on the use of the indicia to instances of a legislator being paid for a representation. I do think the language does that.
I have another suggestion. I think that there are a lot of good points here, following up on Governor Carruthers' concern about the special recognition for attorneys or professionals. And in addition to the changes that I talked about before, to take out the reference to a constituent, so it's clear that they can always do anything for a constituent using their letterhead or so. The change that I want to recommend to the beginning of subsection C that the governor was focusing on is to take out references to attorneys or other professionals, and just have it read that a legislator may appear for, represent, or assist another person for compensation in a matter before a state agency when the legislator is making the appearance or providing the representation or assistance while engaged in the conduct of the legislator's occupation. And then you go on to say that the legislator shall not make references to the legislator's legislative capacity, except as to matters of scheduling, use of legislative stationery, legislative email, or any other indicia of the legislator's legislative capacity when appearing for, representing, or assisting a client in a matter. So we're not giving special treatment to attorneys or other professionals. We're just talking about any legislator who's doing it as part of their occupation. But I do think we need to make clear, as Celia said too, that if a legislator is representing their constituents, they're allowed to refer to themselves as legislators. And the only thing you want to restrict is when a legislator is getting paid to represent anybody, constituent or otherwise, so that they don't refer to their legislative role and try to get special treatment because they're a legislator. But they can still be engaged in the conduct of their occupation, whatever that is, whether they're a lawyer, an economist, or whatever.
Yes, Stuart, can I ask a question? Let's assume I am an auto mechanic, and let's assume I am Speaker of the House. And let's assume I am appearing in front of ExxonMobil, in front of State Tax and Rev. I'm not there with respect to my occupation as an auto mechanic. It ought to be clear to everybody I'm there, that ExxonMobil has hired me because I'm Speaker of the House. And ExxonMobil is going to pay me a lot of money to represent its interests in front of State Tax and Rev, without regard to my being an auto mechanic. They want me because I'm Speaker. And everybody at Tax and Rev is going to know that I'm Speaker. And so it doesn't matter which letterhead I use. And so, I know that we're being asked to answer a specific question because this originally arose where evidently a couple of legislators did not like the Rebecca Dow situation and wanted to carve out something different. And Walker said, wait a minute. And Jeremy said, we want to be consistent with how we treated Rebecca Dow. We want to be consistent going forward. And this is the way we can do that. I again go right back to I don't think legislators ought to get paid for representing anybody for any reason in front of a state agency, period. Anyway, that's my position.
All right, moving on, Commissioner Villanueva.
Yeah, I just had a couple of comments. I had a conversation with Jeremy as well, and I think that the first comment that I had was was like Governor Carruthers mentioned. I don't understand the special attention that's given to the attorneys. So that just blows by me in the first place. And I also take a position. I also had a discussion with Jeremy about what is the difference between a professional and profession. It's just something I kind of had to study academically. I do like Commissioner Baker's position on this, and that's the position I would take if I thought it had a chance to survive. But Commissioner Foy made a point that I thought of in the very beginning. I don't understand why this is so complicated. I think it should simply be any legislator who is compensated is subject to those restrictions. To me, it's just that easy. If I could go a step further, I would choose Commissioner Baker's position.
Right.
So if there was any language, if the language could be simplified, that's how I would say it. Any legislator who is compensated for representing blah, 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 should be subject to the restrictions of using stationery, not making threats, indicating their position, their legislative position. So that would be my suggestion.
Thank you.
I think that's a good one.
My suggestion is all that gets alleviated if we have a full-time professional legislature. And that way nobody can appear because they already have a full-time job and there's just a straight addition.
No, don't ask for that, please.
There is it's getting a little more traction. I was opposed to it for many years for a lot of obvious reasons, probably the ones that cause you to chuckle, but as life gets more complicated, which is probably a product of your friends, the lawyers, more than anybody, Governor, because there's always money to be made in prolonging a problem rather than solving it. I really think that there's some traction. It's not going to happen this year, but it's going that way. But that's the ultimate fix. You get paid to be a legislator, not a professional fill in blank. That's the ultimate fix, but that's not what we're dealing with. I would recommend that we keep this as simple as we can, because they're going to do something. They've already indicated it. They're dropping a bill either today or tomorrow, according to Jeremy's source, and I also have the same information. It's a question of how much they try to do, but this is the starting point. I think that what we have before us and taking out, as Stuart initially suggested, the line about the constituent, and for the benefit of a constituent, and leaving it simply like that, knowing that they're going to do something with it. It is not likely. We are not going to pass something that is binding. We are going to suggest it. The language that we have in there, I think, lets the legislature know where we are coming from. And it's the piece of stone that has not yet been worked on by the sculptor. And I hate to refer to that as any sort of an artistic undertaking, but it's the best metaphor I could think of. And the interesting thing about how big does this legislation go? To your point about killing it, Governor, the more people that add suggestions onto the bill, the less likely I think it probably has a chance of passing. So if they want to go to town on it, there's probably less likelihood of it passing in the form of the elephant rather than the mouse. But I think this is the part we are concerned with that clarifies what was initially thought to be a tempest in a teapot, but is apparently a much bigger issue. So I would do it without getting into a drawdown editing competition, to simply get it up there as a statement of where we're coming from. They're going to do what they're going to do anyway. I have no objection to what anybody has said about stuff, but there's a level of pragmatism, I think, that as to where we are in the session that probably should win the day. But everybody's made comments that are very hard to disagree with from this lawyer.
Mr. Chairman, I want to correct. You said full-time legislator. I'm very much in favor of paying legislators, but not full-time. 12-month legislators would drive us crazy.
I get it. I take your point. Thank you.
But I kind of like what Jeff and Judy have said, or I should get Commissioner Baker and Commissioner. I think and I think Commissioner Bluestone's language initially, if anybody who's in the legislature, who's serving a constituent can do so and do it. But if they're being paid, they can't use any of the perks of the office to do so. And if you're going to write it that simply, I would very much agree that would be the ideal thing for this commission to recommend to the legislature.
That seems to be the consensus. Am I missing something here? Anybody disagree with that?
Chair, I've listened closely, and the language that Commissioner Bluestone has recommended, and we have it all, recorded. I think it captures the concerns that Commissioner Foy Castillo and Carruthers and Villanueva made. And I guess at this point, I'd ask for a motion to make this recommendation as with the amendments that Commissioner Bluestone has suggested.
May I say one thing?
Yes.
Okay, where Councilor Bluestone still uses the word client in C, if we could say assisting another person rather than a client, that takes it out of the idea of only lawyers or people that have clients.
I like that.
Comment. Doesn't person have a definition in the
Yes.
statute?
Yeah, it doesn't have to be an individual. It can be.
Right.
Jeremy, you know that answer better than I do.
Uniform statutory construction.
Right. I do have a comment. I think what sounds threatening about this is that it's directed at the attorneys, at the attorney legislators. So if we maybe change the language or simplify the language so it includes everybody, they won't feel as threatened.
Right. And we are a very sensitive lot.
Try to be an economist sometime.
Yeah, I know it's difficult to draft in committee like this, but as Jeremy said, it's all been recorded and they can work with it. Because we're all clear that we amend subsection B to take out the reference to for the benefit of a constituent, so that it's clear they can do that. And then in the C, if we do something like any legislator who appears for, represents, or assists another person for compensation in a matter before a state agency shall not make references to the legislator's legislative capacity, except as to matters of schedule.
I'm not hearing anything right now.
Right, I think we lost Stuart.
He froze.
He's in Mexico. You can't freeze in Mexico.
He's an attorney, Governor. He's an attorney. He can do anything.
Chair, we have the language that Commissioner Bluestone initially suggested, and with Commissioner Foy Castillo's amendment on person instead of client. We got it.
Yeah. Are we all on the same page, do we think?
Yes.
Yeah. Okay. Let's go forward with that. Stuart, well, thank you in absentia. All right. So now, Chair will entertain a motion to go into executive session if there's one out there.
Oh, Chair, did you make a motion on the recommendation?
Oh, yeah, I'm sorry. I got caught up looking at that. I'm sorry. Motion and a second to adopt the proposed statutory language change as we have discussed and agreed to?
So moved.
Second,
Second,
Second, Commissioner Baker,
yes.
Commissioner Bluestone, if you're there. Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes.
Mr. Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. I will circle back with Stuart, assuming he is with it, since he's the one that proposed the language.
Mr. Chairman?
yes,
if I
sir.
could comment, I think that was a good and lively discussion that had the right outcome. And I think it gives a direction to the legislature that would probably be something that would appeal to them as well. So I just hope it gives Jeremy and others the kind of guidance they need going forward.
It strikes me that everybody did get to the same conclusion, which sometimes is a good thing, sometimes not, but it seemed to get there in the right way, which was with some deliberation, debate, and discussion. So thanks very much for everybody. All right, now I'll entertain a motion to go into closed session. Is there a motion, a second?
So moved.
Second,
Second.
All right, Commissioner Baker,
Yes.
Mr. Bluestone. I'm gonna keep calling him till he answers.
Did we vote on the last one?
Yeah, we're good. Do you want to count as a yes?
Yes, please.
Okay, and then I'll tell you what you voted for later.
Thank you.
Sure. Commissioner
Trust everybody.
Carruthers,
Yes.
Commissioner Castillo,
yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thank you. All right, we'll go into closed session. We'll take 5 while we do that and let the
Yeah, we're all ready and everyone should be able to unmute themselves, have that option toggled when you are in closed session.
commissioners, you will see that some of you may still be or muted, so please take care to rectify that. All right, we're back in open session. And Becky, I first want to just call on you, since we don't have any Rulona matters scheduled, but to let us know that you're alive and well and continuing on that particular track.
I am alive and well. As to Rulona, we've gotten several new complaints this past month, so we will be having things come before you shortly. They're under investigation. We also are watching 2 bills that affect Rulona or notary issues in the Senate. One is Senate Bill 39 and one is Senate Bill 246. And 246 is my understanding is to fix some concerns that the judiciary had with Rulona. So we're watching those. We've actually asked if we could put language in 246 that would allow the commission to promulgate rules for adjudication of Rulona complaints. Any questions?
Anybody? Thanks, Becky. And take care of your voice. You've lost an octave or 2, which I'm assuming was not by choice. So, all right. Now to actions on administrative complaints. Casey, I'm going to turn this over to you.
All right, let's start. Administrative complaint number 2022-038. The commission staff seeks a motion to dismiss based on the Secretary of State's determination that respondent is in voluntary compliance with the Campaign Reporting Act.
Is there a motion second?
So moved.
Second,
All right, any discussion? Hearing none, Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers.
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes, motion carries, dismissed. Next item.
Commission staff seeks a motion to dismiss SEC case number 2022-040 based on the Secretary of State's determination that respondent is in voluntary compliance with the Campaign Reporting Act.
Motion is second.
So moved.
Second,
Second,
Thank you. Any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Recuse.
Thank you. Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. Thank you. Motion carries, dismissed. Next item, Casey.
Commission staff seek a motion to dismiss SEC case number 2022-046 for lack of jurisdiction.
There a motion and a second?
So moved. Second.
Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Motion carries. The matter is dismissed. Next item.
Okay, Chair and Commissioners, I'll take over for the next three. So on administrative complaint number 2022-047, the staff seek a motion that the commission dismiss this administrative complaint and decline to exercise its jurisdiction under section 9C and D of the State Ethics Commission Act.
Thank you. Is there a motion and a second?
So moved.
And I'll second it.
Thank you. It's been moved and seconded to dismiss. Any other discussion? Jeremy, would you briefly outline, there is a distinction between declining jurisdiction and not having jurisdiction, and would you parse that, please, for the members of the public present, just briefly, and I'll come in on top of that if necessary.
Sure, Chair and Commissioners. This is a motion that the Commission has entertained before and acted on before, or the requested motion. The State Ethics Commission has jurisdiction for a number of different categories of personal jurisdiction, different kinds of persons, a number of different statutes. There is the ability under sections 9C and D of the State Ethics Commission Act to not go forward on a case, even though the respondent is within the personal jurisdiction of the commission, and even though the claim is within one of the statutes the commission has subject matter jurisdiction for. The commission has the authority to kind of discretionarily choose when to exercise its power in certain administrative cases and when not to, based on a number of different policy considerations in the commission's judgment. So, Chair, this is a motion under 9C and 9D.
Right, and without getting too far into it's difficult because we can't get into confidential information, but suffice it to say that part of what goes into the discussion when there is a decision by the commission to decline to exercise jurisdiction is looking at totalities of circumstances. Are or were there other avenues pursued by individuals where they could get some type of legal redress? A lot of those types of questions come into the mix, which we had a very lively discussion on that and other issues relative to accepting or declining. But the essence of this entity's, the Ethics Commission's core function is to seek to root out public corruption where there is pay for play or quid pro quo, any sort of allegation where somebody was received a benefit who is a public actor at the expense of doing their state job. And that's primarily why we are in existence. There are other agencies who have concurrent jurisdiction remedies. In this instance, looking at all of those available, all of those options available, that is why the commission, in its wisdom, we'll have a vote first, but essentially that's what we reviewed and debated in a pretty lively fashion, I might say. So having prefaced all of that with the distinction between having jurisdiction and declining to exercise it. Is there a motion? There was a motion in second, I'm sorry. Commissioner Baker,
Yes.
Commissioner Bluestone,
No.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Solomon,
No.
Commissioner Villanueva,
I vote present.
Hmm.
Motion fails.
Okay, then the vote fails. Correct, the motion fails.
Correct.
All right, chair votes yes. Because of the unique requirements of having at least 2 Republicans and 2 Democrats on the side of something it cannot carry because we don't have that math in this case. So the motion fails, which essentially leaves it back in staff's lap, correct, Jeremy?
That's correct.
Right. Okay, next matter, please.
The next matter is Administrative Complaint 2023-001. This is another instance in which the staff seeks a motion to dismiss the complaint, decline to exercise jurisdiction under sections 9C and D of the State Ethics Commission Act.
All right, is there a motion and a second?
So move.
Second.
Any discussion? Commissioner Baker,
Yes.
Mr. Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Villanueva, Solomon, I'm sorry,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes, that matter is dismissed. Okay, is that all of them? 1, 2, 3, 4, 5? Yeah, 1, 2, 3.
One more, Chair.
But there's one more. I'm sorry. That's the extension.
Administrative Complaint number 2022-15. The staff seek a motion to extend the investigation for 90 days.
So move.
Second.
Second.
Okay, any discussion? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes, so the extension is granted. The next meeting by my, I think that concludes, right? Yeah, I'm sorry, Commissioner
Chair.
Villanueva.
Chair, if I could, would you allow me to change a vote?
Yes, that the chair will entertain that.
All right, on 2022-047, I vote yes.
2022-047, the vote has changed from present to affirmative, therefore the motion carries and the matter will be dismissed. Thank you, Commissioner. Anything else substantively, Jeremy?
Chair, there's nothing else. The only other item is next meeting.
Right. The next meeting by our typical calendar would put us in connection on April 7th at 9 o'clock. Does that work? Okay, then we will do that same format. This seems to be working well, so let's not break it. And given the rousing, enthusiastic welcome that we got when we moved it up to Santa Fe, let's just keep it here. We will now turn to public comment.
If I may.
Yeah, I'm sorry.
I believe April 7th is Good Friday. I'm not sure if that makes a difference for anybody.
All Fridays are good. Does that change anybody's perspective?
For what it's worth, I'm going to be out of town, most likely traveling on the 7th. So I would not be able to even do what Stuart is doing by appearing remotely. And I don't know if, does the state of New Mexico regard Good Friday as a state holiday?
My recollection from my court days was that we got this, and I'll use the word advisedly, miraculous memo the Thursday before telling us that there was a spring break to begin at noon the following day. I don't know. We can easily move it. Is the 14th okay with everybody? Does the 7th work better?
Just checking right now.
Thanks. Yeah, everybody check on your stuff. It doesn't matter to me, but if it does to anybody, we just as soon have all of us here if we can.
And the 14th works fine for me.
14th is fine.
Okay. Judy, you okay with that?
I'm good. Thank you.
Ron, how about you?
Still checking, Mr. Chair.
Sure.
We're talking February 14th or April 14th.
Yes.
It's good to go.
Yeah, that looks good.
Okay, so the next meeting will be conducted via Zoom on April 14th.
I'm going to jump in now. If anyone has a public comment they'd like to make, please use the raise hand function under the reactions bar. All right, we have one individual who's asked for public comment. I'm sorry if I interrupted you, Chair.
No, you didn't. You just tightened up the black hole there. So go ahead and please identify yourself.
All right, I'm going to ask you to unmute yourself, Mr. Valdez. Please identify yourself and please provide your public comment.
Okay. All right. Can you hear me?
Yes, sir.
Yes.
So it's well, I'm not sure where to start. First of all, I think the Ethics Commission is incorrect. And first of all, its process, how it deals with its cases and stuff, and that's to only to be allowed to file a complaint, and then there's no comment after that. There's no process for public comment. There's no process for giving testimony regarding the case. So it all appears pretty much one-sided. We do understand the limited role of the commission and being able to determine corruption. It's interesting that they're limited in determining corruption when there's other statutes that definitely apply to corruption. And so it appears that the commission can only do certain things regarding corruption. And the big concern I have regarding our particular case here, 22047.
4415 Echo Canyon Road, Las Cruces, New Mexico.
Am I still allowed to talk?
Yeah, you are. And it's something, somebody's machine interrupted. Sorry about that. Go ahead, Mr. Valdez.
Oh, okay. I need to ask how long am I allowed to talk?
Well, we prefer brief, and as you've probably experienced in your life, the briefer the comment, the more closely people pay attention to it. But I'll leave that to you. If at some point it seems like maybe it's gone on too long or we're going around the same silo, I will ask you to wrap up.
Okay.
Go ahead.
Well, let's see if I can entertain this, where we, the complainants, actually filed a response to Mr. Jeremy Ferris's recommendation to dismiss. Was that heard? Was that response reviewed?
Everything submitted was considered by the commission today, Mr. Valdez.
So how is it that that our complaints about private gain were not considered in our response?
As I said, Mr. Valdez, everything that you submitted was discussed and considered.
Well, I guess what I'm trying to get to is that there's claims that we make in our response that definitely are within your jurisdiction. So, and we understand that you do have discretion whether or not to prosecute, even though it's within your jurisdiction, or not. I shouldn't say prosecute, but to follow through with the case. However, it's not clear why, even though this is within your jurisdiction, and our original complaint might not have been within your jurisdiction, but the additional complaints that we submitted in our response definitely are. So, and so we're baffled and we're not understanding your decision. Or your decision basically is not even understood, I would say, by the public.
Anything further, Mr. Valdez?
Well, just I'd like some responses.
Well, I believe we did. It's very clear that you don't agree with our decision. I don't know what further explanation I could give you other than what I did earlier, which is to say that the commission discussed every aspect of your complaint. We discussed them thoroughly. We declined to exercise jurisdiction on the basis of the entirety of the circumstances, including other opportunities for redress and the lack of specific evidence being presented to the commission of allegations of any type of individual corruption. So, and I believe you already indicated you understood that. You simply don't agree with us, and that's
Well,
fair. We agree to disagree.
Well, let me just close by saying this, that it's remarkable that police that shot a girl 21 times and murdered her, and that there's no ethics violations in that, even though some of these complaints are within your jurisdiction. And it's just remarkable. It doesn't sound, it sounds like you're basically favoring this guys, even though you can actually launch a good investigation. So it's just amazing over a girl who was shot 21 times that there's no accountability. Thank you.
Thank you. Walker, do you have anybody else?
Chair, I do not see anyone else having raised their hand. This concludes public comment.
All right, public comment is concluded. Then we are in adjournment, folks. We'll see you on the 14th of April, if not before. Please be safe and well.